Welcome to this comprehensive guide on the architecture of empowerment, landmark legislations, legal rights, and the enforcement ecosystem in Rajasthan. This explainer is designed specifically for citizens and civil servants to understand how statutory laws grant real rights and how dedicated public institutions enforce them across the state. To understand statutory rights, we must first define their legal blueprint. A legal right is not merely a policy statement or an administrative guideline. It is an enforceable mandate specifically granted to citizens by an act passed by the legislature, whether that is Parliament at the central level or the Rajasthan State Legislative Assembly at the state level. Crucially, a legal right requires an enforcement apparatus, a dedicated institutional body to ensure oversight, execution, and judicial protection. Over the past century, citizen protections in India have systematically expanded across 7 pivotal legislative eras. Beginning in 1929 with foundational protection under the Child Marriage Restraint Act, the framework grew to ensure labor equality through the Maternity Benefit Act of 1961, and market rights via the Consumer Protection Act of 1986. By 2005, a massive paradigm shift occurred with the Right to Information Act and the Mahatma Gandhi National Rural Employment Guarantee Act. This trajectory continued with fundamental educational access under the Right to Education Act in 2009, survival guarantees via the National Food Security Bill in 2011, and modern workplace safety nets established in 2013. These 14 landmark central acts can be categorized into 4 core operational domains. First, transparency and accountability, spearheaded by the Right to Information Act of 2005. Second, economic and labor rights, which includes the Equal Remuneration Act of 1976, the Maternity Benefit Act of 1961, and the Mahatma Gandhi National Rural Employment Guarantee Act of 2005. Third, women and child protection, anchored by the Child Marriage Restraint Act of 1929, the Medical Termination of Pregnancy Act of 1971, the Dowry Prohibition Act of 1985, the Prenatal Diagnostic Techniques Act of 1994, the Domestic Violence Act of 2005, and the Workplace Harassment Act of 2013. And fourth, the Social Welfare Net, covering the Consumer Protection Act of 1986, the Senior Citizens Act of 2007, the Right to Education Act of 2009, and the National Food Security Bill of 2011. Let us examine the Right to Information Act of 2005, which officially came into force on October 12, 2005. Before this legislation, government records were traditionally sealed behind bureaucratic opacity. The RTI Act created a profound disruption by shifting the burden of proof. The state must now justify secrecy, rather than requiring citizens to justify their request for information. This mechanism empowers citizens to demand structural transparency from all public authorities under direct threat of financial penalty. Another monumental act is the Mahatma Gandhi National Rural Employment Guarantee Act, passed in 2005, with its implementation scheme launched on February 2, 2006. MGNREGA operates on 4 cyclical pillars. First, a statutory guarantee providing 100 days of wage employment per rural household every year. Second, labor mobilization that empowers the rural workforce. Third, asset creation, focused on building rural infrastructure and water conservation systems. And fourth, economic security, where direct wage transfers directly stimulate local rural economies. Legal rights do not exist in isolation, they stack together to build an interlocking shield of protection across 3 distinct spheres of life. In the sphere of bodily autonomy, citizens are protected by the Medical Termination of Pregnancy Act of 1971 and the Prenatal Diagnostic Techniques Act of 1994. For domestic safety, protections are anchored by the Dowry Prohibition Act of 1985 and the Protection of Women from Domestic Violence Act of 2005. Finally, for economic and workplace equity, security is mandated by the Maternity Benefit Act of 1961, the Equal Remuneration Act of 1976, and the Workplace Harassment Act of 2013. Together, these social welfare acts transform the state's role from a simple regulator into an active provider of fundamental human capital needs across 3 tiers. At the base level of biological survival, the National Food Security Bill of 2011 ensures basic food access. For generational care, the Maintenance and Welfare of Parents and Senior Citizens Act of 2007 protects aging populations. And for future empowerment, the Right to Free and Compulsory Education Act of 2009 guarantees quality schooling for children. While central acts establish the national baseline, the Rajasthan Legislative Assembly has actively pioneered state-level legislative innovations. Rajasthan customized its governance frameworks to offer higher standards of service delivery and mandatory citizen grievance platforms. This pioneering effort focuses directly on two core areas: time-bound public service delivery and the mandatory right of every citizen to be heard. Rajasthan's civic governance rests on two landmark twin pillars. On the left, the Rajasthan Public Service Guarantee Act, enacted on November 14, 2011. Its core mandate is the time-bound delivery of notified government services. If a service is delayed without valid reason, designated public officers face personal financial penalties. This represents a proactive approach to service delivery. On the right, the Rajasthan Right of Hearing Act, enacted on May 22, 2012. Its core mandate provides a mandatory platform for grievance redressal, granting citizens the right to present complaints directly before public hearing officers within a stipulated time frame. This represents a structured, reactive resolution framework. A legal right is only as robust as the institution mandated to enforce it. Think of statutory acts as government software, while constitutional and statutory bodies form the operational hardware. The executive framework in Rajasthan relies on autonomous commissions to manage statutory compliance, execute public policy, and penalize violations. Let us now map Rajasthan's core oversight watchdogs. The primary guardian of transparency is the Rajasthan State Information Commission. Statutory basis, it was formed on April 18, 2006, under the RTI Act of 2005. Leadership and composition, led by Chief Information Commissioner Devendra Bhushan Gupta, the commission structure consists of one chairperson and up to 10 information commissioners. Enforcement teeth, the commission holds the powers of a civil court, allowing it to summon witnesses and demand official documents. Crucially, it possesses the power to impose financial penalties ranging from 250 rupees up to a maximum of 25,000 rupees on officials who refuse applications or delay information. The protector of human dignity in the state is the Rajasthan State Human Rights Commission. Statutory basis, formed on March 20, 2000, under the Central Protection of Human Rights Act of 1993. Leadership and composition, currently headed by Chairperson Justice Gangaram Mulchandani, its post-2006 amended structure consists of one chairperson and two members. Jurisdiction and limits. The Commission's mandate is to inquire into human rights violations and inspect state-controlled facilities like jails. However, its jurisdiction excludes investigating cases older than 1 year, cases currently pending in court, or matters related to the armed forces. The chief watchdog of administrative accountability is the Lokayukt. Statutory basis, established on February 3, 1973, with Justice I.D. Dua serving as the state's first Lokayukt. Leadership. The current Lokayukt is Justice Pratap Krishna Lohra. Target scope. The Lokayukt investigates allegations of corruption, abuse of authority, and administrative inefficiency against ministers, district heads, mayors, and public servants. Outside jurisdiction, the Lokayukt does not have jurisdiction over the Chief Minister, High Court judges, RPSC members, MLAs, Sarpanchas, or any cases older than 5 years. In summary, here is how the architecture of your rights operates in practice. If information is denied, invoke the RTI Act of 2005 and appeal to the State Information Commission. If you face corruption or bribery demands, invoke the Lokayukt Act of 1973 and report it directly to the Lokayukt. If a public service is delayed, invoke the Public Service Guarantee Act of 2011 and appeal to the designated authority. If your basic dignity or human rights are violated, invoke the Protection of Human Rights Act of 1993 and petition the State Human Rights Commission. An empowered citizen does not just know their rights, they know the exact institutional architecture required to enforce them. Don't forget to subscribe, like, share, comment if you enjoyed this quick revision.